I'm Peter from Williams Legal Services. If you're a landlord or a tenant in Ontario, you might have heard of Bill 184, but exactly what effect will Bill 184 have on the landlord and tenant process when it comes into force? Bill 184, or the Protecting Tenants and Strengthening Community Housing Act, was introduced by the Ontario Minister of Municipal Affairs and Housing in an attempt to streamline the landlord and tenant process and to reduce the backlog of cases currently before the board. The bill will make amendments to the Residential Tenancies Act, which currently oversees most of the residential rental agreements in Ontario. The biggest and most controversial change is in regards to repayment plans. Currently, all eviction and non-payment matters are brought before the board where an order is issued, and usually a repayment plan will be attached to that order. When Bill 184 comes into effect, a landlord will be able to forego the board and offer the tenant his own repayment plan. The reason many tenant advocacy groups are concerned is because if the tenant misses a payment or is short, the landlord can apply directly to the board for an ex parte eviction order without a hearing. Since the changes in Bill 184 are retroactive to March 17, 2020, this could affect many tenants that have already made deals with their landlords during the COVID-19 pandemic. However, Bill 184 is not a total attack on tenants, and there are many changes that could actually benefit tenants, including the raises of fines for unlawful evictions. These unlawful evictions include the landlord claiming that they or their family are moving into the home and they never do, or claiming that they're evicting the tenant for renovations, which they never follow through on. Under Bill 184, the landlord may be liable to pay the tenant up to a year's worth of rent if evictions are found to be in bad faith. Some other changes to the Landlord and Tenant Board under Bill 184 include: tenants will no longer be able to raise issues at a rent arrears hearing without meeting specific requirements such as providing the landlord advance written notice. Illegal rent increases will be deemed legal if the tenant does not challenge the validity of the rent with an application and pays the rent for a full year. Fines under the Residential Tenancies Act are being increased from $25,000 for an individual and $100,000 for a corporation to $50,000 and $200,000 respectively. Landlords will now be able to recover damages from former tenants from the LTB for up to 1 year after the tenant leaves the unit, whereas before the landlord had to go through small claims court. This bill has been the cause of a lot of controversy and even a protest outside Toronto Mayor John Tory's house, which turned into a scuffle with police. Having read Bill 184, I do think that the amendments can actually help tenants. The increased fines will help deter unlawful evictions because the risk won't be worth it. The repayment plans will allow tenants who are able to make the payments a chance to make their rent. Tenants that are unsure of whether or not they should accept the payment should always remember that you are under no obligation to accept an offer from the landlord, and you can still go through the regular hearing process. Obviously, in our legal system, finding a middle ground that's going to make everybody happy is impossible. Anyway, that's a little information on Bill 184. Let me know what you think. As always, if you have any follow-up questions or if you need help with any landlord and tenant matters or small claims issues, be sure to call me at 437-771-5904. For help with traffic tickets and other provincial matters, call Damien at 647-631-5516. I'd like to continue making videos like these, so please follow Williams Legal Services to stay informed.